Hello. Good morning. Yeah. We will start our session today, which is contract and choice. I am Badr Almaskari from Leicester University. I will be the moderator of this session today. First of all, I would like to introduce our speakers. We will start with Daniel. He's coming from Michigan State University School of Law. He teaches and writes on contract law, and he's on contract law in contract law and theory, and the role of law and legal education. He's presenting today on the topic of assent in adhesion contract. He will do the first. He will speak about the first presentation. The second speaker will be Gregory Shill. He graduated from Harvard University Law School. He's professor in international business transaction and international commercial arbitration, corporation and contract. The third speaker will be Helveston from DePaul University. And the last speaker will be Michael, and I would give a brief presentation about him. He's associated professor at Queen, and he's special in philosophy on law. He's teaching contract and tort and remedies. He published widely of the topic of both legal philosophy literature, and law and remedies. So we will start with Daniel, who will be the first speaker for 20 minutes, and we will leave the discussion in the last 15 minutes. So I will hand over.
Thank you. And I think I'm going to try and wow you with, lacking any actual substance, I'm going to wow you with one of the coolest educational apps I've ever seen. This is an app called Doodle Cast. If anyone familiar with this, this is a movie software that when you're teaching, I hate the blackboard, I hate technology, but teaching, if you have a good quality document camera, I've started taking a movie that is running, it's recording my voice, and it records as I draw on the screen, as I draw pictures, write, anything like that. Record a movie, and then you post it for your students afterwards. They've got the entire class with all of your notes walking through in real time. The app is called Doodle Cast. I'm just geeked about it, but I am more geeked about assent in adhesion contracts. So this is a talk that a paper that I prepared for a conference that Larry D. Matteo and Martin Hogg of University of Edinburgh sponsored in Edinburgh in the fall. And this is somewhat developed from that talk, but if you were there before, then it's going to seem somewhat familiar, at least if you were paying attention. All good contracts articles, I think, start with Starbucks. And in this particular case, it's something called a macchiato. Now, macchiato is something that really seems like it should be good. You take two of the best things ever created in the culinary realm. You take whipped cream and espresso, and you put them together, and it sounds amazing, right? It's awful. It's this treacly, nasty, sort of bitter, sweet thing that you have to scrape your tongue to get this taste off of it afterwards. But I saw this thing at the Starbucks. This is a picture of the Starbucks menu. We have a tiny little Starbucks in our business school across the street from the law school, and if you look at the Starbucks menu, we have a series of menu items that you can choose from multiple things, such as a hazelnut macchiato, an iced hazelnut macchiato, a caramel macchiato, an iced caramel macchiato, and a white caramel mocha, along with traditional things like a latte, a venti latte, a cafe mocha, all sorts of stuff. You can get frappuccinos, which I've never had either, but iced coffee, tea, everything. So there's all the normal things that we're used to, but check out the number of choices. I did an analysis of this, and it's actually impossible to figure it out exactly. But there are potentially over 10,000 different possible drinks that you can order off of this menu. It is physically impossible, I submit, to sample, to engage in a fully rational analysis of your possible choices as a consumer of coffee products and paraphernalia at even the tiniest little Starbucks kiosk you're ever going to see. Moreover, if you look very closely down here, it actually comes with some moderate fine print, and then down at the bottom it comes with real fine print, specifying that some models may not be available at some locations, your methods may vary, and so on. So, but the thing is, when I order a macchiato and I get my theoretically tasty coffee drink that is immensely dissatisfying, no one is going to ever feel a grain of compassion for me when I say, Starbucks, you breached your contract. It is unconscionable to serve this thing called a macchiato. I did not properly assent. I did not truly give assent to this macchiato because I really didn't understand what all of these possible combinations were. Maybe I could add caramel to it or drizzle some. No one cares about that. They look at my assent to that contract, to that exchange transaction, and they say, you gave real assent. You wanted that thing, you ordered it, you paid for it, and even you knew you didn't really know what a macchiato is. I know now, and I will never order it again. But it's that idea of what I'm calling selective assent. It is really a powerful tool for creating an unassailable level of assent in contracts. So a level of assent that almost perfectly justifies and legitimates the enforcement of a contract. So let me build up from the background of this paper is looking at adhesion contracts, and everyone wants to criticize adhesion contracts. We have Nancy over here who's just written a great book on why adhesion contracts are problematic and why they may not be. But the critiques follow three large areas. First, the biggest area of critique is that we don't want to enforce adhesion contracts like normal contracts, like our traditional paradigm of contract, because the quality of the assent is very low. We don't really assent. We give Llewellyn's blanket assent or a sort of unknowing manifestation of consent to whatever is in the terms. Wayne Barn has done a lot of work on restatement section 211 sub 3 in the idea that we shouldn't be bound to terms that the drafter knows we wouldn't have agreed to if we had seen them in the contract. But there's a lot of critiques that arise out of this idea of assent. The rest of the critiques follow from fairness and democratic ideals. Peter Linzer has a great little article in Pace, an essay dealing with the idea of domination by private business interests. We've seen that before in Nathan Isaacs and Berlin Means and others. The fairness argument that adhesion contracts are fundamentally unfair, that there's a class of terms that should not be enforced against consumers. So I'm going to put these two aside and focus on the idea of assent. All right, so the classically liberal paradigm of contract, which I'm calling Contracts version 1.0. In the classically liberal paradigm, contract is normatively justified by reference to assent. We mobilize the enforcement powers of the states. And for those of you South Park fans, this is Janet Reno in a fuzzy bunny suit, invading, throwing bombs, tanks, everything coming in to enforce the contract because we presume the parties have assented to that enforcement, to the mobilization of the enforcement power of the state. Well, the problem is that this idea of justifying contract enforcement because of assent begins to fail when we start moving away from traditional contract paradigms, when we start looking at standard form contracts, and particularly when we look at standard form contracts in the online context. The level of assent in those contexts bears no resemblance to the level of assent that we have in Roscoe Pound's Roscoe Pound's famous example of two farmers haggling over the sale of a horse, or Margaret Jane Radin's more recent example of Tom and Sally haggling over the sale of a bike. This transaction is what we seem to see as the ideal of assent. I can look at a horse, I can bargain over that horse, and I can assess, do I really want that particular horse? Do I want that particular bike in exchange for my money? Well, the problem is that for those of you who actually know anything about horses, Pound was full of something. Horses are hard to figure. I grew up on a horse farm. I know horses. I know I don't really want to deal with them. But we have never really satisfied that ideal norm of assent, that ideal high quality of assent in practice. Horses are complex animals. Horses, there are things that go wrong with horses. For any of you who have ever bought a pet, for example, you're probably more familiar with what happens when you buy a dog and all the things. My dog apparently just developed an allergy to chicken, which is in everything. And it is a room-clearing experience in dealing with this. But there are always hidden factors and hidden issues and informational advantages and bargaining power advantages, even in this idealized assent situation. Second, as I'll talk about at the end of my presentation, ideal assent would not necessarily solve the problems that we attribute to adhesion contract. The main thesis of this paper is that even in situations where we can create the best possible simulacra of assent, if we can do everything that causes the parties to pay attention to the contract, to actually say, I want this and not that, we still will likely have the same problems that we see in the adhesion contract context. And then finally, the idealization, as I already noted, does not legitimate. It doesn't work in a system where, as David Slauson pointed out, 99% plus of all contracts are in fact standard form contracts of adhesion. So that was contract 1.0, the famous two farmers haggling over a horse. The reality of contracts is Carnival Cruise Lines. I'm calling this contracts version 2.0. This is what really happens. Again, the 99% of all contracts are standard form contracts, mostly standard form contracts of adhesion. I don't see Amy Schmitz, but she's got a lot of really good, high quality empirical research on the ability of consumers to bargain out of standard forms and consumer expectations in standard form contexts. The types of assent that are given in the standard form context. If we have contract 1.0, the assent is a high quality. In contract 2.0, the assent is a very low quality, and we can even make it. We can even increase or decrease the quality of assent by moving into later iterations of contract 2.0 of the standard form contracting model. That's the Hill versus Gateway. That's and the rolling contracts model, and so on. The quality of assent is all the way at the bottom, at least from the consumer perspective. The bargaining power in this situation is extremely problematic. The consumer in these situations typically does not have strong information regarding the likelihood of failure of the contract or likelihood of dispute regarding the contract. The consumer is often unsophisticated with respect to the goods. The consumer may be may be subject to a monopoly situation, or the consumer isn't, like in the cell phone context, the consumer may simply be completely overwhelmed, often deliberately, by the complexity of the choices that the consumer is facing. So what I'm trying to move on to is we see in the contracts 2.0 scenario several tools and several situations in which courts seem to require movement from, if we have the contracts 1.0, if we seem to require movement from this low quality of assent up to some middle ground. The area where the courts require some additional indicia of assent by the consumer, where the consumer may, for example, in some cases be required to initial next to particular terms of the contract, where a great deal of work has been done over the last decade or so on the effectiveness of mandatory disclosures, where we're concerned about consumers not being able to identify what their interests are, what the terms are, what the weaknesses are in their contracts. And so the standard response has been, well, let's disclose the interest rate, let's disclose the payment terms, and so on. We may also require, such as with the disclaimers, the implied warranty of merchantability, that the disclaimer be especially conspicuous and laid out so as to draw attention to the consumer. We may mandate particular language. We'll see this again in the liability waiver and exculpatory clause context. A number of jurisdictions require, by common law, not by statute, they require certain magic words in order for a liability waiver clause to actually work. In those jurisdictions, the producer actually has to say that you are waiving your claims against us even for our own negligence, and that our own negligence is a magic word that must be present in some jurisdictions, or the waiver is ineffective. In some cases, we give we look to the contract rules regarding handwritten terms in a standard form contract. And in unconscionability cases, there is an analysis of there's a case-by-case analysis of whether the assent by one party was actually meaningful, whether they had alternative choices to the proposed contract. But I want to really introduce this concept of selection assent, this middle ground, in the context of exculpatory clauses. And the case that I use for this, the paradigm case I use for this, is Boucher versus Reiner, which is a pre-internet case from 1986. In this case, this is a contract for the provision of parachuting training and recreational parachute activities. And the contract contained in paragraph 2A a relatively vanilla, normal, complex, hard to understand. I got to admit, when I read through this, my brain sort of shuts down when I'm looking at this block quote. The participant exempts and releases a whole bunch of people from any and all liability, claims, demands, or actions or causes of action arising out of any damage, loss, or injury to the participant's property, essential, everything that could go wrong were free and clear. All right, so that's normal. We're used to seeing this type of clause. But what we're not used to seeing is this next clause, paragraph 2B. Paragraph 2B provides, in consideration of the deletion of the provisions of paragraph 2A regarding exemption from liability, the participant has paid the additional sum of $300 upon execution of this agreement, receipt of which is acknowledged by the corporation. This clause right here, in a paper contracting context, this clause right here has taken the normal paradigm of, they just handed me a contract, you know what, it's just words on a paper, I really want to go parachuting, dude, and where do I sign? That's what usually happens, and has taken that and moved it into, hey, now I have a real choice. They are asking me to say, do I prefer cheap parachuting services, or do I prefer to pay for insurance at as far as I could tell from the case, it's roughly market rate for a one-off, no investigation umbrella liability policy for jumping out of an airplane. I can pay more for my preferred terms, and we see this in several scholars' work. We see this in several scholars' work, but with this, I'll get to that in a second. Selection assent, this idea of selection assent raises a possibility that we may be moving away from contracts 2.0, where the standard form imposed contract, into possibly contracts 3.0, in which both sides now have the ability to engage in meaningful interactions meaningful effects upon the proposed terms of the contract. Contract 3.0, this idea that we want to provide consumers the power, the ability to negotiate or select the terms of their contract, is something that we're already seeing in the technological context. We have the ability to do this. Well, actually, I was excited to see that Kingsley Martin from KM Standards is going to be speaking at lunch today. I've never seen him, so if you're in the room, I'm sorry, but my office is next door to Dan Katz, and I hear Kingsley Martin's name all the time. They are developing a coding system for evaluating and engaging in computer algorithms to select, to allow parties to get together and say, let's not draft this contract from scratch. Let's not choose the form that's been sitting in the code in the form bank since 1898. Let's actually go on to use the computer algorithm to say, here's what we want to achieve. Find us a selection of terms, and we'll choose the best terms that can construct our contract. Ken Adams has done a similar process with his document assembly firm, Concision, and there's even an app for that called Shake that allows individuals to engage in micro-contracting and develop their own contract terms. See, the thing I love about this is it's got a timer, so I can tell how far I'm about to go over. So the idealization of assent, we have models of selective assent, and Nancy Kim in both a series of articles and in her recent book has suggested, well, in some cases we may want to prefer that terms are that parties identify, I accept or I reject specific contract terms. Margaret Jane Radin in 2 articles around 2000. Proposed that instead we should have a system where you can pay an additional $1.24 for the right to litigate instead of arbitrate. I'm envisioning a world where producers will provide a series of checkboxes like you see in the shipping terms on Amazon.com, where you say, I'd like 2-day shipping or next week shipping or bulk rate shipping or something like that. But provide it and price every term out there. The effect of this is that it's not as benign as it sounds, because if producers are still allowed to price their contract terms, and I am almost finished, if producers are allowed to price out their contract terms, there is nothing out there that stops them from pricing the consumer preferred terms sufficiently high, as in a parallel to Cass Sunstein's nudge, as sufficiently high to guide all or almost all of their consumers into the producer's preferred contract terms. But if they do that, if they engage in this idea of selective assent, then what they have done is create a doppelganger of assent that may be indistinguishable from the assent that is given from the farmers haggling over the horse. And it may actually be of a higher quality because you have focused the consumer on every term of the contract and say, pick A or B, or pick A, B, or C. And the consumer has actually exercised their volition to engage in that contract term. Plus, we've taken away the absence of meaningful choices argument from unconscionability. Plus, we have limited, in some ways, we may be limiting the consumer's ability to engage in meaningful contracts. So I am out of time, and I will stop there and let the next.
Thank you so much for your excellent presentation. We will listen to the next speaker. Please be on time. 20 minutes only.
Morning, everybody. My name is Greg Shill. I'm a visiting assistant professor at the University of Denver Sturm College of Law. Thank you to Jennifer and all the other folks involved in organizing this wonderful conference and for arranging such nice weather. That was very thoughtful of you for those of us coming from colder climates, which I think is most or all of us here on this panel. Today I'm presenting a paper called Boilerplate Shock. This paper addresses a conceptual gap in the literature concerning the aggregate impact of standardized contracts on a market. So the paper primarily addresses this concept in the context of securities contracts, specifically contracts for European sovereign debt or bonds issued by Eurozone countries among 18 members of the Eurozone. These contracts are often governed by boilerplate, as we know, and they're adopted with little to no deliberation, a theme we've seen already this morning. Boilerplate literature is very consumer focused. There's a lot of concern about assent. There's a lot of concern about sort of social justice issues, adhesion, things like that, choice. There is a companion literature much smaller on financial contracting, boilerplate. And this literature primarily focuses on the efficiency of boilerplate as used between sophisticated commercial parties versus the concept that terms are simply used and reused because they're sticky. They become commonplace, and then the market doesn't really reevaluate them. They just become part of the meme of the deal. So again, this analysis is firms. The first analysis is consumer-centric, or if you like, social justice-oriented. The second set of literature is really focused on efficiency of firms, sort of law and economics. To date, there's been little to no discussion of the aggregate impact of using boilerplate terms on the market. So this paper addresses the impact of choice, which I put in quotation marks because I argue the choice of boilerplate terms is not truly a choice, standardization on the financial system. So since 2008, there's been an intense focus in financial regulation, securities law, on minimizing systemic risk, the chance that an isolated default could bring down the entire economy. The role of contract design in perhaps facilitating this has been neglected. So I introduced this term for this concept, boilerplate shock, the potential for standardized terms in securities contracts to create or exacerbate systemic risk. In other words, the risk that when adopted market-wide, boilerplate can create severe externalities. The problem, of course, here is not simply that a term in principle could be bad and therefore could disadvantage a party that adopts it and perhaps make it more likely to default and lose some money. The point is, if all of the contracts that are used within a particular market use those same terms, then once one party defaults, then holders of debt issued under the same contracts will have reason to believe that their debt is worth much less money, which will then cause them to sell the debt, sell the bonds, et cetera, much more quickly, and will be very hard for similarly situated issuers of debt to continue borrowing money. So what does this mean in the Eurozone context? It would mean that a country like Greece could leave the Euro, default, and then the terms that govern its bonds, since they're, if in fact they are held to default, also those terms also govern Italian and Portuguese, and Irish, for that matter, French and German bonds as well. So the risk is that the borrowing costs of particularly of the so-called peripheral countries would go way up in the wake of a default, even more than they would already because of the exit of, let's say, Greece. We'll stick with Greece for purposes of simplicity. Okay, so what you're seeing here is the spread, or the premium paid by Greece to borrow money on the international markets between February of 2010 and July of 2013. The spread peaks. This is Greek versus German, which is German is the benchmark bond for the Eurozone. The spread peaks almost 30% in March of 2012, meaning that Greece has to pay 28.5% more, an interest rate of 28.5% more than Germany. They have to pay 10.5%. Sorry, they have to pay 30% in March of 2012, and the Germans have to pay something about 1.6 at that time. So that's unsustainable, and as you see, there's a big drop-off after the Greek debt restructuring, and since then, the trend's been downward. If I updated the chart, you would see the trend, the spread continued to compress since this date. But no one really thinks that the crisis is over. So the risk is especially pronounced in systemically significant markets like European sovereign bonds. But some of you may be asking, what do lawyers really have to do with this? What does contract design really have to do with this? And in a minute, I'll get into the specific terms of the contracts that I'm talking about. But to back up for a minute, most people think of this problem as being primarily dictated by economics or perhaps politics. So what do lawyers really have to say about this? And of course, the meta issues will be driven by political and economic considerations. There's no serious debate about that. But where there ought to be more attention, I argue, is to the private international law dimension of the problem through the vehicle of these sovereign bonds. So lawyers may look like this sometimes, but can still be quite relevant or quite able to exacerbate an already existing risk. So what are the boilerplate terms that I'm talking about here? There's an internal conflict of laws, I argue, built into each one of these sovereign bonds. There is the law of the contract itself. Almost invariably, sovereign debt contracts contain choice of law clauses or governing law clauses. For most of the world, these clauses specify the application of New York or English law. Some countries can borrow under their own law, but the market, for historical reasons, prefers New York and English law. This is also true for European sovereign debt. Even countries like Germany and France, which have long established records in the credit markets, will often borrow under New York or English law. And countries like Greece, today now all of their bonds, almost 98% or so, are governed by English law. So there is this governing law clause, and it's boilerplate. It just says what you think it says. Any disputes arising under this contract will be governed by the law of X. There is an alternative source of law implicitly named in the contract, however, something called the law of the currency. It's a concept known as lex monetae. This is the law that governs the payment term of the contract. And implicitly, that law is the law of the country that issues the currency named. So if you have a contract in dollars, US dollars, you are implicitly incorporating the definition of US dollars as dictated by US law, even if your contract is governed by French law. That's the basic contour. Now the problem here is that when it comes to foreign exchange rates. So today we live in a world of mostly free-floating currencies. So if you want to buy euros here in Miami, you can go to a bank or a foreign exchange dealer and buy them whatever the market rate is. That is not the case because of law. That can be changed. And so what observers expect is that in the event that a country like Greece were to leave the euro, it would try to effect a unilateral debt restructuring by introducing its new currency, which I'll call the new drachma, and officially, formally, legally valuing that currency to the euro higher than market rates. What that means is that they would, if the market says there are 10 new drachmas to the euro, Greece could say there are 3. Why would they do that? Well, they've just shaved off 70% of their debt if they can succeed in repaying their debt in their new currency. Of course, their creditors would have something to say about that and would probably sue claiming breach of contract. So again, we get back to the relevance of courts and of contracts. Okay, now then the question becomes whether a court would, whether the departing state would be allowed to discharge its contract in the new currency. And the reason they might be able to is because of the law of the currency concept, lex monetae, that by naming euro in the contract, the parties have implicitly allowed for any changes in the definition of the euro. To back up briefly, of course, the real problem here is that when these bonds were issued, it's about $10 trillion right now in outstanding European sovereign debt, nobody was really thinking about the possibility that Greece or another country might depart. So there are no provisions in the bonds for what happens in the event of a departure. Similarly, there's no mechanism in the European Monetary Union for leaving the euro. So there's sort of a change circumstances situation, and we need to put our contract hats on and think about how we would interpret the party's intent at the time of contracting when clearly they weren't considering it at all. So the cases, there are no direct precedents for this, but the cases that most closely parallel where you have a country changing currency focus on the party's intent. Okay. So based on these cases, some commentators, I would say the consensus view is that the law of the currency would prevail. But really these commentators, two of whom have now passed away, Michael Grusin and a gentleman by the name of Mann, as well as someone named Nussbaum. There are a number of monetary theorists in the late 20th century, all three of them. And Hockett, who's a professor at Cornell, they believe that the law of the currency would govern. And they base this on what I argue are really constitutional law cases, not contract law cases, about the power of the United States government to issue paper currency despite the fact that there's no constitutional provision for that expressly written. And so based on some public policy principles and U.S. constitutional law principles, the Supreme Court validated that in the legal tender cases and later the Gold Clause cases in the late 19th century and during the Great Depression. I argue these cases are really irrelevant to the discussion of contract law. There are more recent cases interpreting New York law that indicate that the law of the contract is likely to prevail. And again, these reach that conclusion by looking at the party's intent. The upshot is that they say that the parties intended to exclude the currency law by naming the governing law of the contract, such that the law of New York would say preclude any currency regulations of Argentina. The Second Circuit just said that in the fall of 2012 in the latest round of their 2001 default litigation. Now that decision and the others that the paper talks about don't make that argument explicitly. But what they do is they put up on one hand a New York law contract that, in the case of Argentina, for example, precludes discriminatory treatment of creditors. And on the other hand, they put up the law of the country here, Argentina, that discriminates against certain creditors. And they say, well, clearly the parties prohibited that by contract. But the implication of that is that this contract, governed by New York law, can be allowed to override the mandatory law of a foreign country, at least as applied in U.S. courts, as a matter of private international law. The other cases are similar. If this analysis is accurate, that means that not only is Greece more likely to default, meaning not only would any exit followed by redenomination, Greece left and tried to redenominate its roughly 200 billion euro in debt into new drachmas. Not only would that be ruled a default, but imagine you're an investor, you read the decision holding that Greece has defaulted, and you hold Italian debt. You're Deutsche Bank, and you hold billions and billions of euro in Italian debt that is governed by identical terms. What do you want to do with that debt? The market currently does not expect this. The consensus expectation is that a country like Greece would be allowed to redenominate, at least in the United States. I argue that is misplaced. And so this is the shock concept of the paper, is that if you're a holder of this debt, you're going to want to sell immediately. And similarly, if you're a country like Italy or Belgium or Portugal, it's going to be very hard for you to continue to borrow in this climate. And the bailout institutions that currently exist, like the European Central Bank and the International Monetary Fund, do not have the resources to provide a stopgap for all of these countries if that happens. So the solution that the paper proposes is a new default rule of contract interpretation that would presume a country to have retained the right to change its currency and redenominate any debts, unless it issues in a foreign currency to begin with, or it affirmatively waives that right in the transaction documents, usually the offering memorandum issued by the issuer. On the first point, issuing in a foreign currency, take Argentina. Argentina for years borrowed in United States dollars and did so under New York law. In that case, I would argue there ought to be a strong presumption that, in fact, the borrower is trying to take account of the risk that it will default. That, in other words, that investors are demanding that the issuer place its bonds beyond the reach of its national law and even beyond the reach of its central bank by issuing in a foreign currency to begin with. They're subjecting themselves to American currency fluctuations, the policy of the Federal Reserve, by selecting United States currency. So I would argue that the benefit of this rule shouldn't flow to an issuer like Argentina that issues in a foreign currency. In the case of Greece, even if it left the euro, it can't really be said that it issued in a foreign currency. It's issued in a currency that it borrowed in a currency that it is part of, a full member of, fully participates in. And no one really believes, and I've talked to a number of people on the finance side, people who work in derivatives, as well as securities lawyers on the issuer side. And as far as I can tell, and including my own research beyond that, no one really considered this possibility when they selected currency of payment or governing law for these bonds. Okay. Advantages of a default rule is to force an active negotiation. It is possible that the issuer would simply just waive its right to redenominate, as it could under this rule. And so then arguably we'd be back to where we are today. But I would argue that at least flushes the issue out into the open. The problem today is the risk of surprise, the risk that, as I said, there could be a bank run following a single holding of default, and at least if the issue is out in the open, then the chance of that is reduced. Also, it would allow the issuer and investors to work out some creative solutions. It doesn't have to be black or white. It's possible that, let's say, Greece could issue debt and reserve the right to redenominate, but also secure its bonds by mortgaging revenue streams on assets that it holds outside of its territory, things like that. There is already evidence that there is potential for creative structuring of these deals among sovereigns and their investors. So I think this rule would continue that trend. And I would argue this rule would align the law with the normative consensus. The normative consensus today is that if a country like Greece left and defaulted, that shouldn't bring down the world economy. I'm pleased to align myself with that normative consensus. I think that would be bad. People talk about it as being Europe's Lehman moment, although most people think it would be far worse than the demise of Lehman Brothers. The problem is that the law doesn't take account of that. Now, some objections. Wouldn't courts just bend the rules to save the world? If it's really as bad as I'm saying, aren't they just going to throw the book out the window and say, we're going to call this a one-off? I think that's extremely unlikely. It's always possible, but the existing case law today, at least in New York law, suggests otherwise. In fact, courts routinely cite public policy as a reason to uphold the contract. In other words, to require payment in euro. If you contracted to agree to pay in euro and the euro continues to exist, then there's no impossibility or frustration argument. You must pay in euro. Why? Commercial certainty, preserve the status of New York as the global center of banking, et cetera. Expectations of the parties. So if the euro completely dissolves, then I think then they would kind of wing it and save the world. But in the more likely event that there is a partial dissolution, but it continues to exist, existing case law suggests that they would enforce the contract as written. It will disrupt the market. That's one reason why it's a default rule, so that it doesn't upset parties' expectations, prospective only, so as not to affect the marketability of existing debt. And then there's the argument, I think, that waivers are not a bad thing, even if it formally gets us back to where we are now. There are a few open questions here that I'm happy to address when we turn to questions, namely having to do with how do we address this type of externality in the future. If, one could conceive of different institutional choices to deal with this, regulators, legal ethics, work on norms and sort of boosting the culture of securities lawyers against this, to be on the lookout for this sort of risk. But I think it raises some questions about whether that's feasible, as well as how that might apply outside of the context of boilerplate. Thank you.
Many thanks for that. Thank you so much for the excellent presentation. Let's move to the third speaker.
Hi all, I'm Max Helveston. I teach at DePaul. I'm going to be talking about a paper, no PowerPoint, sorry, or not sorry, depending on your predilection, that I have written with a senior colleague of mine at DePaul, Professor Mike Jacobs. Before I do that, one note, I see some people are knitting. It's very cold in Chicago. I recommend you donate to the Professor Helveston Hat and Glove Fund. I'll pick those up tomorrow. And second, I wasn't aware of the Starbucks rule, but I think I can incorporate this into my talk. So, in the course of teaching first-year contracts, as Professor Jacobs and I do, you run into the bargaining power doctrine, right? We have a number of cases where the bargaining power of the parties is talked about by courts as perhaps one of the things to consider when we're talking about whether we should enforce a contract or not. And so I was going to talk about one of those cases, so like maybe Batsakis v. DeMattis, Alaska's Packers Association, Williams v. Walker Thomas, but instead I'll talk about Starbucks. So right now, we wouldn't say if you go to Starbucks and you buy a terrible macchiato that you have a claim against them that they violated your contract, right? Especially a bargaining power claim. A court would laugh at you, as would most people. But we can kind of build out from this hypothetical and try to create a case, right? Starbucks dominates the Chicago market. They buy out everybody. The only place you can get a coffee or a terrible macchiato is at Starbucks, right? And like me, you're addicted to coffee. You drink about 10 cups a day. I'm pretty sure I could have tried all 10,000 combinations of their menu. And Starbucks starts demanding either a lot of money or some really weird terms that we are concerned might be abusive, right? We could address that problem in a lot of ways, but there are examples of times when courts will say, nope, too much bargaining power here, too bad of a term, let's not enforce that contract, right? One of our equitable exceptions to the general enforceability of negotiated contracts. Professor Jacobs and I were talking, not at a Starbucks, but it could have been, so let's make that up, about this issue, and we just struck by how many actually open questions there are when we talk about bargaining power. What is it? How much of it is too much? How could we measure it? Does it vary within context? What are some alternatives to it? So we started to do some research, and I guess I'll start by talking about kind of the case law that we uncovered. So you think of all of these older cases as involving bargaining power issues, but there are plenty of modern cases as well. And they tend to not talk about what bargaining power is as much as just state that it exists, that one party has it, and therefore a contract should not be enforceable or should be enforceable anyway, but we're doing it really grudgingly because it's not really fair to the little individual consumer, right? We looked way back to try to figure out where this started, and there's a Supreme Court case from about 1890-something involving employment, an employment contract. And the Supreme Court's like, if there's too much bargaining power on one side, then the other side hasn't really consented to this contract. And that kind of line of thought developed forever, and probably the most famous case where we see it is Williams v. Walker Thomas, where we have a destitute woman or a woman of little means purchasing furniture with this kind of insane clawback provision if she defaults on the payment. And they're like, oh, she didn't consent to this. Sure, she walked into the store. Sure, she saw the furniture. Sure, she signed the contract. Sure, she paid money under it. But there was actually no real consent. That might make sense to lawyers, but to the standard person, that is insane. So how do we get there? Well, courts say, when is bargaining power too much? And we have to kind of figure out what criteria they've used. So they tend to look at one or multiple of three things. First, are there alternatives, right? Could you go and buy macchiato elsewhere, right? Can you go to Intelligentsia? I guess that's a Chicago thing. Starbucks, Dunkin' Donuts, etc. If you can, bargaining power is not an issue. Second, negotiability, right? So this is our standard form contract discussion. Could you negotiate the terms of the contract, right? Could you say, nah, I want to pay less. No, I want my macchiato to be less disgusting, maybe add some caramel, whatever Professor Barnhizer would prefer. And then third, and this one is kind of harder to work in, the characteristics of the party. So am I a person who is of little means, little education, not so smart, really gullible, or am I some super swanky, sophisticated, well-paid law professor? It's most definitely the former, not so much the latter. And if that's the case, courts are going to be more likely to invalidate that contract based on bargaining power issues. But although courts kind of use these three criteria, there's no real consensus within themselves or across jurisdictions about which of these is most important and how to measure them, right? So courts haven't really defined it, and they don't even agree on how to detect it. And none of this gives us any kind of quantification, right? We can say someone's more or less sophisticated. We can say that there are some alternatives around, but we can't really say, is there really an alternative to a Starbucks macchiato? Is a cappuccino enough from down the street, or is coffee from a restaurant about the same? These kind of measurement issues are prolific and unavoidable. Jumping over a little bit, when they do find these bargaining power issues, where do they fit this into kind of our doctrine? Well, I don't want to spend too much time on it, but essentially unconscionability in public policy is where this fits in. They say, oh, this contract was unconscionable because someone agreed to it when the process wasn't quite fair. Or they say, the public is kind of against this term, and there was a deficit of bargaining power on the weaker party, therefore unenforceable. Okay, so we've got a bunch of cases, we've got a bunch of criteria, nothing too clear yet. So we're like, oh, we know, law professors are smart, they will have figured this out, right? No. So we did some research, and there's actually not that many articles on talking about bargaining power in the context of contract law. Actually, probably one of the most comprehensive articles was written by Professor Barnhizer, discussing the history of it, what is power, different ways you could measure it. But most pieces just talk about it in general and say, oh, we should use this bargaining power doctrine more to police standard form contracts, to kind of punish these exploitative corporations' behavior. Even the in-depth articles didn't really come up with a definition of bargaining power that we really liked, right? We can describe it in general. Everyone knows what it is. Economists can talk about it. But when we're talking about how to measure it, it's not like, oh, he has 10 bargaining power and I have 1, right? That doesn't make any sense. And it's also contextual, right? So if a corporation is negotiating with another corporation, and they're of equal strength, you might be like, oh, there's no bargaining power problem. But what if one is under a contract to create a specialized part for the other, and then midway through the contract says, hey, actually I want more money, right? Then bargaining power situation looks very, very different. So we have to, if we're going to use this bargaining power doctrine to invalidate contracts, we should have some level of consistency and some level of objectivity. But courts haven't found any way to objectively measure it. Academics haven't really identified any way either. So what do? Well, you try to think of a solution, and then we gave up. So we said, down with bargaining power. And here essentially is the heart of our critique. So first, again, it's the measurement problem, right? Courts, in order to try to, you can't just say any disparity in bargaining power is enough to invalidate a contract, right? Because every deal is going to have some disparity. So they always talk about like, oh, it's a large disparity or a substantial power disparity between the parties. Well, that's not really that helpful. You can tell the difference between a large gap and perhaps a not so large gap, but you're still going to have all these measurement problems at the margins, right? So that doesn't help a ton. Well, some courts then look at proxies, right? Are we dealing with a corporation versus an individual? Is this a boilerplate contract? But even then, you can't just use a single proxy, because a boilerplate contract, for instance, isn't going to be objectionable if you have an option between 20 other vendors who use different boilerplate contracts, at least according to most people. And corporate status isn't going to really matter if you're in a market where actually consumers have a lot of options and can dictate to the corporation through, well, purchasing power. Well, what about other proxies? Skill or wealth? Well, those aren't really measurable either. There's a lot of books out there that try to teach you to be a good negotiator, but again, you're not going to get skilled on a 10 to 1. You're not going to get graded on a 1 to 10 scale unless I'm grading you at like an ABA negotiations competition, in which case I guarantee you I am being very arbitrary. It's mostly how much coffee have I had, what round are we in, am I sleepy, did my pug keep me up, those types of things. So the other real option that we see is that we could look at just unfair outcomes, right? So does this contract contain an unfair outcome? And if it does, then that would indicate that the parties have such a disparate bargaining power that we should not enforce this. But in order to do that, we have to come up with an idea of what a fair contract would be between the same two parties. And that's not so easy, right? That's why we have the market, right? We don't say, oh, a coffee is objectively worth $2 right now. We say, hey, there's a lot of competition. How much can, how little will you pay for a coffee? And that determines the fair price. And conceivably, the same thing works for terms. So we have the problem of measurement. We also have a problem with just a theoretical inconsistency with other parts of contract law, right? We have no duty to negotiate, no duty of good faith when we're talking about negotiations, and we have no duty to actually enter into contracts at all. So we can exert all of our power, right, all of our economic power pre-contract to get the best deal possible. This is the foundation of our economy and why we all have Apple products and wonderful, wonderful things, at least according to The Economist. So why, if we allow people to do that pre-contract, can we then post hoc, ex ante or ex post, say, you used too much power, you got too good of a deal, let's invalidate that contract? Theoretically, it just doesn't make sense, right? You can't create rules that allow people to accrue power and then use it, and then just ad hoc be like, nah, we don't like the look of that. And there's just so many problems with that, both rule of law, consistency, and efficiency, right? No one can plan around such rules. Starbucks can't say, okay, well, let's not get any more market share here because then all of our contracts will be invalidated for bargaining power. And then third, this isn't so much a critique. So we have the measurement problem, we have the theoretical inconsistency. We can look into an area of law that at least my co-author, who's an antitrust scholar, thinks is superior, right? Antitrust. There we talk about not so much bargaining power, but monopoly power, right? But we have clear rules about what the monopolists can and cannot do. First, we define who they are. Second, we say you can price up to monopoly prices. You can do whatever you want. You just can't inhibit other competition, right? That's in sharp contrast to contract law, where we have no definition of how much bargaining power is too much, and we have no clear delineation about what you can and cannot do once you have power over another party. And conceivably, this is why antitrust at least gets talked about as yielding competitive benefits and innovation benefits, whereas our kind of more humble common law doctrine and contracts would hurt both of those, right? If parties have to worry about their contracts being invalidated, they're not going to innovate, they're not going to try to capture as much of the surplus as possible, and people will be less motivated to do stuff to make money. Okay. So maybe I've sold some people, maybe I haven't. But what do you do as an alternative, right? If we get rid of this doctrine, conceivably some of these unfair contracts are going to be enforced more often, right? Because this doctrine is used to invalidate things, or at least some deals. Well, there isn't really a problem here because we have so many other tools to address these types of problems. Great. Sorry. If you look at what contracts bargaining power is used to invalidate, they all have one quality in common, a disparity or substantial disparity in bargaining power, but then they have one of three other qualities. They have terms that we say are essentially objectively unfair, or they're the result of a negotiation process that we are uncomfortable with, or they deal with parties whose capacity to consent has been somehow externally reduced. Well, we can address all of these through legislation and regulation, and in fact, we already do, right? So, substantive terms. We use statutory and regulatory measures all the time to dictate the terms of contracts. The FTC regulations control what you can have in loans and credit cards. OSHA and minimum wage laws dictate terms within employment contracts. The ACA dictates terms within insurance policies, right? So if we can identify terms that are problematic, right, they're universally problematic, we can just ban them. No problem, and it's universal, it's predictable, parties have fair notice of it, et cetera. What about negotiation? Well, FTC and state laws, let's say, prohibit door-to-door sales, right? We used to be really concerned about these in the 1970s. People would come knock on the door and Granny would answer it and she'd be like, oh yeah, I'll buy the Britannica for $5,000. Market price for Britannica, $500. And a lot of courts invalidated these under the bargaining power doctrine. Well, again, FTC stepped in, we regulate it, not a huge problem. Again, for these kind of procedural things, the ACA, I'm an insurance person, so I like to talk insurance, regulates how insurers can essentially negotiate and price things pre-contract with individuals. And then finally, when we're talking about diminished capacity, what do I mean by that? So hurricane strikes. Oh, we're in Florida, so that makes sense. Hurricane strikes, right? Everyone needs gasoline. There's not a lot of gasoline. So people start price gouging, right? So we have statutes, which personally I think are insane and don't make any sense, that say those contracts, if they are determined to be substantially unfair, are invalid, right? We also have, at least some states are now contemplating passing statutes that kind of protect elderly individuals when we're talking about financial contracts, right? So we can identify individuals whose capacity contract is not non-existent, but is reduced by some external effect and try to protect them that way. And if we do this, yeah, we're robbing the judiciary of another one of its equitable doctrines, and yeah, we might have some unfairness every once in a while. But we kind of need that unfairness every once in a while, or else we won't motivate legislatures and regulators to do the things that they are made to do. The only reason we have FTC regulations on door-to-door sales, or the only reason we have the ACA's prohibition on discriminating against people with pre-existing conditions, is because those things stunk, right? And they really hurt people, and that motivated the legislators and regulators to address them. Doing things on an ad hoc basis through judicial doctrines, it's not only inconsistent and economically not justified, right? Parties can't plan for it, et cetera. There's just so many better alternatives. So obviously our conclusion is that the bargaining power doctrine doesn't make any sense. We should move on and put the onus where it's supposed to be, in situations where we can plan ahead, consider the global impacts of our rules instead of a case-by-case analysis. And I'm done early. I talk fast. Let's all get Starbucks. We have 2.5 minutes, right?
No, I just didn't.
Thank you so much for the excellent presentation.
I started a timer.
Our last speaker, Professor Michael, will give last presentation. Then we will have a discussion for 15 minutes.
So how do I get my PowerPoint up? There we go. All right. So I think this is the first time I've ever used PowerPoint. So Daniel's using, what is it called? Doodle Cast. As my 11-year-old son would say, I'm a complete noob when it comes to technology and presentations. Anyway, hello everybody. I'd like to thank Jennifer, who's now departed, I guess, but for putting this conference together. It's just dizzying in the amount of organization it must have taken. I've made a title change, so those in your itinerary, it has a different title. My paper has a different title, but it is the same paper. This paper is one of a series of pieces I've written over the years on the problem of voluntary obligations in law and morality. So one of my main interests is the nature and justification for obligations such as those that arise from contracts and promises that have a voluntary basis or component to them. And in this particular paper, I attempt to draw some theoretical conclusions about the nature, the voluntary nature or the voluntary character of contractual obligations from a fairly straightforward doctrinal premise. I say fairly straightforward doctrinal premise from a Canadian point of view. I'll be speaking to Canadian law for the most part, which diverges from from what I understand the law to be in most states here, and that divergence I think is somewhat interesting. So we can talk about that perhaps in the Q&A after if we have any time. Canada versus the U.S., by the way, that's happening at noon today. We need to be out by then. Okay, so let me start by saying something about what I mean by a voluntary obligation. So an obligation can be voluntary in a sort of weak or attenuated sense, just insofar as it can be avoided. So we could define a voluntary obligation as one that attaches to an act that the actor knows that the performance of which will attract that obligation. And he can perform the act. I can get behind the wheel of a car and acquire the obligation to drive with care, or I can choose not to do that. And if I am aware that I attract an obligation to drive with care and getting behind the wheel, then that obligation when I get behind the wheel is in some sense, a weak sense, voluntary. But that sense of voluntariness doesn't capture the robust, distinctive way in which contractual obligations are voluntary and can be distinguished from those in tort or other areas of law. And so I'm going to stipulate a definition or an understanding of voluntary obligations. I can do this. I'll define a voluntary obligation not in terms of the mental state or the psychological state of the obligor, the person who's obligated, but rather in terms of the justificatory conditions or triggering conditions of the obligation. So an obligation is voluntary if and only if it is one that can be acquired by an agent or an actor only if he or she intends to acquire it. So I'll stipulate that as my understanding of a voluntary obligation. It's a very robust definition of voluntariness. And this then you can see eliminates obligations like the one I suggested, getting behind the wheel of a car, even if I have the intention, even if I, for some perverse reason, like to get behind the wheel of a car just in order to acquire the obligation to drive with care and discharge it, it's still not a voluntary obligation under my definition. So what I want to ask is to what extent a contractual obligation is voluntary. Legal orthodoxy certainly says it is, and there's enough jurisprudence on this, at least in Anglo-Canadian law, judicial authority for the proposition that contractual obligations can obtain and attach to a party only if they intend to acquire a legal obligation by their agreement are widespread. You have no problem finding it from Balfour and Balfour, which I think is something Americans law students would be aware of. From Balfour and Balfour on down, we get a clear doctrinal proposition that most first-year Canadian law students would know within the first 3 weeks of law school, that there must be an intention to create legal relations in order to create a contract. Despite the doctrinal authority, though, and the judicial authority for the proposition, skepticism remains, both among judges and scholars, as to whether there is in fact a voluntariness requirement in contract. The skepticism arises from various sources. One common objection is something like the objective theory of contract formation objection, that even if there is such a requirement, it is only the objective theory, it is only the objective intention to be bound that we are concerned with. It's not true subjective intention. It's an objection I've never found very moving for reasons that it would take another paper really to explicate. But the gist of it is, if it is the case that we have an objective theory of contract formation, it seems to me that is actually an affirmation of the consensual or voluntary nature of contractual obligations. We are, after all, through the objective theory, protecting the reasonable promisee's understanding of when a contract has been formed. We ask from the promisee's point of view, have the requirements of contract formation been satisfied? Well, they will have if that promisee believes the promisor intended to be bound. So it seems to me that the objective theory is parasitic on. It presupposes that contractual obligations are fundamentally voluntary creatures. Let me just put that objection aside then and move on. There are other skeptics out there who think Balfour and its progeny are all about, it's not, as much as they may speak the language of contractual intent, they are really and truly about keeping contract in its place, right? As the scholar Stephen Headley, who's now at University College Cork, wrote a paper some time ago in the mid-'80s, I think, called Keeping Contract in Its Place, about Balfour and Balfour, arguing that contract law has no place in the non-arm's length world, in a sense that it has no place in family relations or friendships, etc. And that is really what judges under the auspices of the intention to create legal relations are trying to do. So there is doubt out there about whether there is such a requirement as an intention to create legal relations in the law of contract. What I want to do in this paper, what I attempt to do is look at a class of cases that I call the disclaimer cases. Now I'm going to stipulate what I mean by disclaimer because it's a capacious term. I will mean by a disclaimer a manifestation, an unambiguous manifestation of the parties to an agreement that they do not intend their contract to have their agreement to have contractual effect. It is an unambiguous indication that the parties intend their agreement to be binding in honor only, for example. One of the leading Anglo-Canadian cases is one that I know some U.S. scholars have talked about in their own papers, a case called Rose and Frank versus Crompton Brothers, involving a long-term supply contract where the parties included what they called an honor clause in their otherwise very dense legalese-looking agreement, indicating that the agreement was binding in honor only, and the court held that that's indeed the case. It didn't take contractual effect. I want to then proffer the following proposition of law, which I think is indubitable. You can't dissent from it, at least in Canadian law. That is, a disclaimer, a clearly worded disclaimer, will always be effective. The parties to an agreement, if they make manifest their intention to avoid a contractual obligation, will avoid a contractual obligation. There is no case I'm aware of that dissents from that. Although I think this is perhaps partly where the U.S. and Canadian law might diverge. And so what I want to do is I want to take these cases, these disclaimer cases like Rose and Frank, and try to draw out from them some theoretical conclusions. So it's a kind of Cartesian inquiry. I'm going to start with something that I regard as indubitable, that contractual obligations are what I call disclaimer sensitive. They will not obtain if there's a disclaimer between the parties in the agreement. And I want to try to see to what extent we can infer voluntariness from that. That is, to what extent can we infer from that the contractual obligations require an intention to create legal relations. A number of authors and some judges, I think, fall prey to the suggestion that the inference from disclaimer sensitivity to voluntariness is actually quite straightforward. So in most Canadian case books or textbooks on contract law, you see Rose and Frank and its ilk cited under a chapter called the intention to create legal relations, as though it's a clear indication or it's a clear support for the intention to create legal relations requirement. The thinking goes something like this. If the parties include a disclaimer, there is no contract. Therefore, and what is a disclaimer? It's evidence that the parties don't intend to be bound. Therefore, it follows that contractual obligations require an intention to be bound. That inference is false, though. The mistake is that a disclaimer is indeed evidence that the parties lack an intention to be bound, but it is not just evidence of that. It is also evidence of an intention not to be bound. And the distinction then, those two facts, that A and B do not intend to be bound and that they intend not to be bound, are different. I think often in this context of Corbyn's example of the two very naive farmers trading a horse for a cow, and they don't know anything about the law. They've never heard of a legal obligation or intention to create legal relations. So on the one hand, they have no intention to create legal relations, but nor do they have an intention not to. So then we've got a problem then, right? And this is in this paper. The burden of this paper is to try to show that despite the inference from disclaimer sensitivity to voluntariness is not straightforward, it is one that I think nevertheless can be made. But it's involved. The inference is involved, and it's going to take us fairly. It gets technical in my paper, and I'm just going to try to. I'm just going to scratch the surface of it here. What I attempt to do in the paper is raise a kind of thought experiment. So I ask the reader to imagine two worlds in which two parties, A and B, make an agreement. In the first world, A and B make an agreement that satisfies all of the criteria of contract formation, the necessary and sufficient criteria of contract formation, which I've stipulated to be C1 through CN in my overhead here. Overhead, that's an overhead. That's what I'm used to using. The transparent things that are plastic. Yes. So in the first world, then, all of the conditions are satisfied, and the parties acquire this obligation, which I'll call it it's the contractual obligation. I'm then defining another possible world, the second world. The second world is the nearest possible world to the first. The only difference is it differs from the first world just insofar as it is necessary to change that world to create a disclaimer between the parties. The parties have taken the same agreement in the same circumstances, and they've added a disclaimer to it. And so it follows from the premise that I'm starting with, that obligations in contract are disclaimer sensitive, that the parties in the second world acquire no contractual obligation O. And then what I do in my paper is I attempt to determine which of the conditions, the necessary conditions of contract formation, is unsatisfied in the second world that renders the agreement not binding in contract. Two possibilities present themselves. The one I favor, obviously, is that there is a voluntariness condition among this set of conditions C that stipulates that the parties will not be bound in contract law except insofar as they have intended to be bound in contract to a legal obligation. But there's another possibility. The possibility is that there is a condition, I call it in my paper CA, it's an avoidability condition. So under this, so this candidate would where am I here? Just a second. Sorry, I should have had that up earlier. So voluntariness thesis is the one I favor. The alternative, the only potentially plausible alternative I can imagine is an avoidability thesis, which holds that even if the parties which holds that it is not a requirement of contract formation that the parties intend to be bound. However, if the parties do not intend to be bound in contract or in law, then that fact is sufficient to displace displace or defeat the obligation in contract. So it is irrelevant whether the parties intend to be bound, but if they intend to avoid a contractual obligation, that will defeat any contractual obligation that would otherwise be in play. And my paper is really a sustained attempt to show that the avoidability thesis, which I think, by the way, is presupposed by Section 21 of the American Restatement of Contracts, second, which basically says one need not have an intention to create a legal obligation in order to create a contract. However, the intention to avoid a contractual obligation will typically or often be successful, something like that. So my paper is a sustained attempt to show that the avoidability thesis is conceptually incoherent. It's not morally, no coherent theory of obligation can sustain it. And the burden there is the paper gets a bit technical, but in broad outline, my argument is this. The voluntariness thesis, and I realize I'm just about out of time here, the voluntariness thesis that I am advocating for implies what I call this principle P. It's simple enough despite the algebra that it looks like it has. The fact that A and B intended to avoid acquiring this obligation, contractual obligation, when making their agreement, is a sufficient reason to preclude them from acquiring this obligation, despite that in the first world, right, when they didn't have a disclaimer, that act of making the same agreement in exactly the same circumstances was sufficient to generate an obligation on A to B and B to A in contract, despite that act in the first world was sufficient to generate O. The avoidability thesis says if the parties then engage in the same act, make the same agreement in the same circumstances, and simply qualify it with a disclaimer, it will defeat the obligation that would have otherwise have obtained. That, I think, is implausible and can't be justified coherently. And the reason again, it looks like I'm speaking Greek, in the Inertness Principle here, this is what I call it. The basic thought, I won't go through the Inertness Principle, I'll let you read it at your leisure, is basically this. If A and B do the same thing in both worlds, and in the first world what they do together is sufficient to cause one person's interests to be affected by the other person's act in such a way that he can demand something of the other. A can demand that B deliver the widgets. B can demand that A pay the price. That if that is true, then the intentions with which they engage in that act, in particular the fact that they intended to engage in it without acquiring a legal obligation, can make no moral difference, no normative difference. Right? So if it is the case that if I steal your bike or take your bike without your permission, then I acquire an obligation to make restitution to you by paying you back or returning your bike, then it seems to me it makes no difference. It clearly makes no difference that I take your bike with the intention not to acquire that obligation to make restitution. And I want to say, what's the difference if the act isn't stealing a bike but making an agreement? But that's the overview. I didn't put my paper out on the shelf outside, but I'm happy to send it to anybody who wants it. Just fire me off an email. Thanks for your attention.
Thank you, Professor. All right, for the excellent presentation, and we will open the discussion for 15 minutes. So, yes.
So that's to me. I'm kind of having a problem with the idea that we can define consent here in this in 5 minutes. But I share the problem, right? I mean, I help run a small business. I lay awake at night worrying about the battle of the forms and consequential damages. How do I make sure that my terms, I write adhesion contracts, my terms and only my terms are the ones that I want in there? And I literally I will fire any of our employees, and I'm not kidding about that, who deviates from my form language, who does something that triggers a battle of the forms or gives assent to someone else's language. I think that the reason that we tend to focus on the consumer is because of the bargaining power issue that Max brought out. We just presume that the businesses can watch after themselves. We presume they have access to lawyers. That's false. But it's still the focus of scholarship for the last 100 years has been on what is the nature of the consent of the adherent, and kind of figuring that if the business really wanted to make sure that it didn't sell to anyone who was going to litigate in Washington, that it could do something extra to protect itself, like the particularized assent that I was listing off in the contract. So the easiest way to get absolute assent, bring a lawyer. If you have a lawyer, you show me a case with that has a lawyer representing a person on the consumer side that gets an unconscionability analysis. I'll be shocked. Other ways show they put it in handwriting, put a initial next to it, to show that there was some additional attention paid to that term that actually brought it to the attention, and that the consumer knowingly assented to that term. Does that help, or did I answer it? Just not well.
I'll chime in on that too.
Yeah.
I can't speak for my co-author, but it's the exact same problem as with bargaining power. It's kind of a common, it's like a folk concept, right? Bargaining power and consent. It makes sense. We talk about it. We all know what it is, but it's immeasurable and therefore not useful to try to use as a legal device. The only way that consent can become useful is, for instance, I think in, let's say, medical transactions, right? So you consent to a surgery. We have defined what consent means exactly, right? You have to know the risk of the surgery. You have to have advance notice. You have to sign off on these things. If we come up with a statutory or regulatory definition of consent, then we can actually talk about whether someone legally consented or not. But as long as it's not defined in any way, I think you just end up with two people taking very different views, right? And neither can be right or wrong. So with these consumer contracts, did they consent or did they not consent? It's irrelevant because you can't answer it objectively. All we could do is say, these terms are all right, these terms are not. Any transaction, let's say the purchase of a ticket that goes through this process is legally enforceable, and we won't even bring consent into it. That'd be my view. Yeah, a bunch of good points. I guess I'll go in reverse order. So the contract with a problematic term, and the court is going to enforce it. So we saw that all the time with health insurance contracts pre-ACA, right? Someone has cancer, they don't know about it, they buy a health insurance contract, they seek care after purchasing the contract, the insurer seeks to rescind based on the fact that the person had a pre-existing condition, and courts would enforce that, right? And that stunk for a lot of people for a couple decades. But now we end up with a regulatory or a legislative solution that kind of addresses that. I think the problem with relying too heavily on these equitable doctrines is they're case by case. Only some judges are going to do that. Some judges will take sympathy on the poor person who gets screwed by the pre-existing condition term, and other ones won't. Why not wait for there to be a critical mass of attention and the political process to mandate a fair solution for everybody? Relatedly, I guess jumping back to your first point, I didn't talk about it. We do discuss the possibility that other doctrinal areas or doctrinal defenses to enforcement could fill in some of the gap. So judges could use, let's say, misrepresentation, frustration of purpose, some things like that to try to, if there's a really, really inequitable contract out there that has not been, let's say it's totally new, so there's no chance that legislation could have addressed it. So that power is always going to reside in the courts. We just think that the bargaining power construct is particularly poor because of it just doesn't generate any kind of clear guidance to parties. So perhaps use these other doctrines, although a lot of them will end up with the same measurement problems. But ideal solution is to actually have, I think, a process-oriented solution.
That's a great question. Thanks for that. So why are we going to bend over backwards to let rich commercial parties out of their boilerplate contracts, which they didn't bother to negotiate, even though they paid millions of dollars in legal fees to draft? Two reasons. One, which are really the same, which is it gets to the nature of the offering, the nature of the transaction. So we think of getting a loan from a bank as an individual as being a basically two-party transaction. Perhaps the loan is guaranteed by the FHA, but that is not the way these bonds work. So formally, the issuer will sell the debt to syndicated underwriters, which are banks, but then they will turn around and what is technically, as a matter of securities law, conduct a secondary transaction to sell the debt to a bunch of investors, like banks and other institutional investors, and then the debt just sort of flows out into the secondary market and is traded on a daily basis. So the bargaining that so one answer is that there's not a lot of incentive for the parties to the initial transaction to actively negotiate their boilerplate, because the risk of any defects in contract formation will be immediately offloaded to future purchasers, unless you are really a strong believer in the efficient markets hypothesis for contract terms. Then you recognize there's some problem there that's not going to trickle all the way up to the primary offering. But the second point is that society has an interest in preventing the risk of a global meltdown over and above whatever the risk of any individual holder of these debts might be. So if you're a bank and you have billions of dollars at risk, that's a problem for you. But if banks the world over have this problem and there's the risk of a real liquidity freeze or the inability of these countries to continue borrowing money on the private markets, then that becomes a larger problem.
I would like to thank our speaker for their excellent presentation, and I think now it's lunchtime, so thank you so much for your attention.